Good. Excuse me, everyone. Sorry. Can we all please take a seat? It's really loud. If we can get everyone to turn off your phones, computers, any form of electronic device so that we have no sounds going on to the final round, that would be greatly appreciated. Oh, and sorry, also if you guys, the speakers in front of you, if you can all make sure they're all turned off, that none of the red lights are on. And be wary of them during the final round. Okay, great. So first, I'd like to introduce myself. My name is Naveed Froessel. I'm the chair of the Moot Court Association, and I wanted to thank all of you for coming. So I wanted to thank all of you for coming here today to the 38th Annual Charles W. Froessel Competition. This competition, we host two competitions every year, one being the Charles W. Froessel Competition and one being the Robert F. Wagner Competition, which is the largest labor and employment competition in the country. The thing with the Charles W. Froessel Competition, it's one we hold close to heart for the sole reason that we're the only or one of the very, very few moot court associations in the country that's student run. And you can see from the rounds you've done in the last 4 days that this is a competition that students work with all their heart, put full work into these competitions and rounds, many of whom have not taken constitutional law and still learn the material in order to compete in the competition. Your hard work and success is shown here with the 4 competitors left at the final round and all of you that are here today and have joined the Moot Court Association. So I'd first like to ask everyone to please give a round of applause to the final 4 and all of you that have made the Moot Court Association. Thank you. So first I'd like to give a few thank yous that'll be the start of many thank yous throughout the day before we start the final round. I wanted to start by thanking our Vice Chair, Veronica Przgocki, and our PR and Media Chair, Pekna Singh, who did an awesome job calculating scores to make sure all of you knew it as soon as possible. I'd also like to thank our Froessel authors, Evan Bain and Khalil El-Assad, writing an amazing fact pattern that challenged each and every one of you and that gave you the opportunity to be here today to join the Moot Court Association. And last but not least, I wanted to thank our Froessel co-chairs that have worked tirelessly, endlessly throughout the whole summer while we were enjoying our time. They were here every day working to make sure this competition ran flawlessly, and that's Jason Sherritt and Aruna Chitiapa. And even though these were all members associated with the Froessel competition, I wanted to thank each and every executive board member and general body member of the Moot Court Association that really picked up slack, helped us timekeep, judge rounds, and contributed greatly to this competition. So if we can give a round of applause to all these members, please. Thank you again. So without further ado, I'm going to turn the mic over to our Froessel co-chairs, which is Aruna Chitiapa and Jason Sherritt. Thanks again, guys, and good luck to you, Final Four.
Good afternoon, everyone. Welcome to the 38th Annual Charles W. Froessel Final Round. If everyone can just give a brief round of applause for everyone here, because you really, really deserve it. My name is Jason Sherritt, and this is my co-chair, Aruna Chitiapa. We are so incredibly impressed with everyone in this room, and we would first like to extend a thank you to the 2014-2015 Moot Court Association, the e-board, and just general members. Without you, we could not have done any of this. Between you asking us, coming in hours that you weren't scheduled, helping us doing everything anytime we asked, whether it be timekeeping, judging, working the front door, this could not have run without you, and we extend you our sincerest thank you.
Round of applause, please. So let's begin with our tributes. First to Khalil El-Assad and Evan Bain. Thank you very much. This was a great fact pattern. I think I heard a lot of the judges even calling the issues extremely sexy, which is pretty unheard of in a competition. So it was a great fact pattern. I think we're all looking forward to seeing our top 4 competitors compete and argue these issues and really bring and breathe life into the pages that you've studied all summer long. We'd like to also thank Professor Nadine Strawson for her guidance and help right through the entire summer and after. The fact pattern would not have been complete without her. A special thank you to Dean Crowell and Dean Archer and all the faculty, staff, administration, and adjunct faculty as well, who've helped us in assembling schedules, allowing students to either take an absence or helping us to figure out their schedule so we could have this competition run without a hitch. A special thank you to our executive editors, Brian Knoll and Michael Froessel. Every piece of literature that the Moot Court Association creates, writes, produces, and disperses goes through their very capable hands and eyes. And so we are truly very grateful. To all the other e-board members, Pekna Singh, our Public Relations Chair, Natisha Matthews and Jennifer Jimenez, our Wagner co-chairs, and Gafar Zaloff and Khushbu Patel, our Wagner authors, a big thank you. The e-board this year, we are family, and I truly felt like one during this competition. Our general body members, you went above and beyond. Every time we needed you, you were there. You always had a smile on your face, 8 o'clock in the morning, even though we'd been out the night before. It was great fun to work with you, and we are truly so grateful to become so close, and thank you very much.
We'd also like to extend a thank you to our faculty administrator, Stephen Cunningham. He is the general behind the scenes who is there for us day in and day out. He made sure that every room was booked, every podium was there, every paper was printed out, and we, honestly, without his tireless effort to help us, we could not have run this. So we do want to extend him a special thank you as well.
We would also like to thank Professor Susan Abraham, our faculty advisor, who oversees the Moot Court Association. A big thank you for her eternal guidance and advice, without which this association and the competitions we run would not be complete. And finally, we have special guests in the audience, parents, friends, and high school students who have come and taken time out of their extremely busy schedules and on a Sunday to be here with us. So a round of applause for our special guests, please. A big thank you to all our competitors, those who didn't make it but still enhanced the competition, and those who did make it. This competition and this team would be incomplete without you. So thank you for being with us here today. We'd like to begin by reading out the bios of the judges and the bench behind us today. So let's start with Professor Susan J. Abraham. Can we start? After.
Professor Susan J. Abraham is a professor of law at New York Law School, where she teaches evidence, advanced appellate advocacy, and principles of legal analysis. Professor Abraham also serves as the New York Law School Moot Court faculty advisor. She has represented indigent criminal defendants in New York and New Jersey at both the trial and appellate level, and has also represented clients in disability discrimination, employment, criminal, pension, and other matters. Susan Abraham earned her BA in English from Oberlin College in 1977, her JD from Rutgers Law School in 1983, and received an MFA in creative writing from Warren Wilson College in 1991. The Honorable Brian Cogan. The Honorable Brian M. Cogan was appointed to the United States District Court for the Eastern District of New York by President George W. Bush on May 4, 2006. Judge Cogan obtained his BA degree from University of Illinois at Champaign-Urbana in 1975 and his JD degree from Cornell Law School in 1979, where he was a member of the Board of Editors of the Cornell Law Review. From 1979 to 1980, Judge Cogan served as a law clerk for Judge Sidney N. Aronovitz in the United States District Court for the Southern District of Florida. Upon completion of his clerkship, Judge Cogan became an associate at Strzok & Lavin, where he spent his entire career prior to his appointment to the bench, becoming a partner in 1988 and general counsel to the firm in 2004. He had a commercial litigation practice concentrating on complex litigation, accountants' liability, and securities fraud, insolvency, and cross-border litigation. Prior to his appointment to the bench, Judge Kogan served as Vice Chairman of the Mayor's Committee of the Appointment of City Marshals and was a member of the Appellate Division, First Department, Departmental Disciplinary Committee.
Our third judge is the Honorable Joseph E. Irenas. The Honorable Joseph E. Irenas was appointed by former President George H.W. Bush as a federal judge for the United States District Court for the District of New Jersey on November 14, 1991, and was confirmed by the Senate on April 8, 1992. Prior to serving as a federal judge, he began his career in private practice, working at McCarter & English from 1966 to 1992. Judge Irenas has also served as an adjunct professor at Rutgers University since 1985. A native of Newark, New Jersey, Judge Irenas holds a BA from Princeton University and a JD from Harvard Law School, from which he graduated cum laude. He assumed senior status on July 1, 2002. And the last judge on the final round bench is the Honorable Alan Kocholski. Alan Kocholski graduated from the University of Rochester in 1977 and from New York Law School in 1980. His office is in Rye Brook, New York, where his practice includes criminal representation at the trial and appellate level, as well as matrimonial, civil litigation, and FAA enforcement proceedings. In 2008, Mr. Kocholski applied for a concealed carry permit, citing the Second Amendment, as well as random violence such as the Virginia Tech shooting, in which 31 persons were killed, as the requisite factors to establish proper cause for the issuance of a carry permit. When his application was denied on the ground that he did not state any facts which would demonstrate a need for self-protection distinguishable from that of the general public, he appealed to the Second Department, which affirmed the denial. Mr. Kocholski then appealed to the Court of Appeals, which dismissed his appeal on the ground that no substantial constitutional question was directly involved, although Justice Smith wrote a strong dissent. Recognizing the importance of the issue, the Second Amendment Foundation joined in the cause and retained Alan Gura, who had prevailed in various Second Amendment battles before the Supreme Court, including D.C. v. Heller and McDonald v. Chicago. Mr. Gura litigated the case in the Southern District of New York and then in the United States Court of Appeals for the Second Circuit. A big thank you to our final round bench, please. We would like to invite the Froessel co-authors, Khalil El-Assad and Evan Bain, to now read out the summary of the facts.
Hello. So I don't know if everyone knows it, but we actually split the issues. So I wrote on the Second Amendment, Khalil wrote on the REFRA issue, so we're each going to read our respective facts aloud. So this is a summary of the facts for the Second Amendment issue. Since 2001, the state of Froessel has had the highest rate of handgun violence in the country and the slowest police response time in all the states. In 2001 alone, there were roughly 3,000 firearm-related homicides in the state of Froessel. Between 2001 and 2007, the number of firearm-related homicides in the state steadily increased to roughly 6,000 per year, with the majority occurring in public. In 2007, responding to the crime epidemic in the state of Froessel, the legislature enacted the Froessel Concealed Carry Law, FCCL, which prohibits citizens from openly carrying firearms and requires citizens who wish to carry a concealed firearm to demonstrate a justifiable need and obtain a training certificate. Since the enactment of the FCCL, over 20,000 residents have applied for a concealed carry permit, but only 50 applicants were found to satisfy the justifiable need requirement. Moreover, a recent study arguably cast doubt on the FCCL's overall effectiveness in reducing public violence and the crime rate in general. Although from 2007 to 2013, the number of reported homicides remained roughly at 6,000 per year, all homicides occurred in public and were committed with firearms. Another study shows that the number of handguns sold in Froessel has steadily decreased from 70,000 in 2007 to 10,000 in 2013. After falling victim to an assault and a near-fatal incident involving a firearm, respondent Jeff Liu sought to obtain a concealed carry permit, believing he could satisfy the FCCL's justifiable need requirement. Respondent applied for a concealed carry permit, but his application was denied because the state police department determined that the assault and incident fell short of demonstrating a justifiable need under the FCCL.
All right. The Froessel Concealed Carry Law also contained a requirement that anyone wishing to obtain a training certificate, that anyone wishing to carry a firearm obtain a training certificate. Section 3 of the FCCL prohibits firing ranges in the state from discriminating against customers on the basis of race, gender, and religious affiliation. Jeff Liu operates the Peacekeeper, which is the only firing range in the city of Gotham. While there are 5 other firing ranges in Froessel that are authorized to issue the requisite certification, the closest one is 120 miles north of Gotham. Sigmund Young, a devout Satanist, visited the Peacekeeper to obtain a training certificate so that he could apply for a concealed carry permit under the FCCL. However, when Sigmund entered Jeff's place of business, Jeff noticed that Sigmund's necklace depicted the symbol of the Satanic Church of Gotham. Jeff, a self-professed Christian, ordered Sigmund to leave his store and refused to provide Sigmund with the training necessary to obtain a training certificate. Jeff did so because he interprets his Christian faith as requiring him to refrain from any transaction, commercial or otherwise, with Satanists. Jeff believes that he is entitled to a religious exemption under the RFRA from FCCL's anti-discrimination provision. Thank you.
I know there's been a lot of reading. We're almost done. We'd just like to briefly read the bio of Charles W. Froessel, after whom we've named our recruitment program, aka this competition. The Moot Court Association and the entire New York Law School community proudly honor our distinguished alumnus, Charles W. Froessel, by hosting this competition in his honor. Charles W. Froessel received both a Bachelor of Law and a Master's of Law degree from New York Law School in 1913. He was an honored leader in his profession, serving the state of New York with distinction. His roles in public service included Sheriff of Queens County, Assistant District Attorney in Queens County, Special Assistant to the United States Attorney General, Justice of the City Court of the City of New York, and Associate Judge of the New York Court of Appeals. Charles W. Froessel was also Chairman of the Judicial Section of the New York Bar Association and President of the Queens County Bar Association. Devoted to legal education and the law, he served with distinction as a professor and member of the Board of Trustees of New York Law School. I'd like to quickly introduce our final 4 competitors. As petitioner 1, we have counsel Catherine DeSalvo. Arguing on behalf of petitioner 2, we have Kimberly Gay. On behalf of respondent 1, we have Trayvon Luncheon. And finally, on behalf of respondent 2, we have Nicole Mosey. Congratulations to the top 4 finalists, and we wish you a good round.
of business before this, the Honorable Supreme Court of the United States, are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. The Supreme Court of the United States is now in session. Justices Kogan, Pachalski, Abraham, and Chief Justice Irenas presiding.
Everyone, please be seated.
The first case on the calendar of this 14th day of September 2014 is the State of Froessel petitioner versus Jeff Liu respondent.
Your Honor, may I approach?
Yes, you may.
Good afternoon, Chief Justices. Your Honor, may it please the Court. My name is Catherine DeSalvo, and I, along with my co-counsel, Ms. Kimberly Gay, represent the State of Froessel, the petitioner on this appeal. Your Honor, before I begin, may I please request 2 minutes rebuttal time?
Granted.
Thank you. The petitioner respectfully asks this court to reverse the decision of the United States Court of Appeals for the 13th Circuit and hold that the Froessel concealed carry law does not violate the Second Amendment of the United States Constitution for the following 3 reasons. First, as this court held in 2008 in the case District of Columbia versus Heller, the right to carry arms is confined to one's home. Secondly, the Froessel concealed carry law does not warrant invalidation because it cannot possibly be equated with a prohibition on the right to bear arms. Third, even if this court were to find that the right to bear arms does extend outside of one's home, the Froessel concealed carry law survives intermediate scrutiny. Now, Your Honors, this case is about ensuring the public safety of the citizens of Froessel in a state that is currently being plagued by violence and bloodshed. This
case is also about the Second Amendment and the reach of that amendment. And I just wanted to ask, your first reason was that this court confined the Second Amendment to the home. Could you tell me where in Heller that language is that makes it so explicitly confined to the home? I mean, not confined to the home, outside the home?
State believes that the right is confined to the home, that the right to bear.
Where in Heller
Right, Your
does
Honor.
it say that the right is confined to the home and doesn't extend to the right to carry a firearm outside the home?
Well, the right to bear arms confined to the home is explicitly stated in Heller within the facts. The facts of the case do state that the prohibition in the District of Columbia was on the right to bear arms in one's home.
Didn't the court say something like, well, that's the core of the Second Amendment, but it didn't necessarily limit it to the home, did it? Is there any specific language in Heller that says the right doesn't extend outside the home and made that absolutely a part of the holding?
No, Your Honor, that is not necessarily part of the holding, and that is what has led us to be here as the arbitrary interpretation of Heller. However, the state contends that the core right of the Second Amendment, as Justice Abraham, you
The
just...
Second Amendment refers to keeping and bearing arms.
Yes, Your Honor.
Correct?
Yes, Your Honor.
Keeping in a house, you don't think about bearing arms. You don't say, I'm going to bear an arm and go to the bathroom, or bear arms and go cook a meal. Bearing arms really almost inherently implies public, carrying them out in the public. Keeping arms is different. And if it had only the word keep, maybe Heller could be construed as applying only to the home. But don't you, how do you reconcile the use of the words keep and bear arms?
Yes, Your Honor. Well, this court and lower circuit courts have interpreted and gone through an exhaustive historical analysis on whether the words keep and bear and what they do mean and how they operate within this amendment. However, if I could point the court's attention to the prefatory clause of the well-regulated militia, that has also been interpreted to some contend that the Second Amendment is limited to only militia, but it has certainly been interpreted throughout the history.
What's your position? Is your position that the bearing arms portion of the amendment only applies to militia?
No, Your Honor. No, Your Honor. That's
What does bear mean?
Bear means to carry arms. In this case, in this case at hand.
And then it necessarily means outside the home, right?
Your Honor, although the state does not believe that it means outside of the home, the state still can prevail on their argument because the Froessel concealed carry law passes intermediate scrutiny. If the right were to extend outside of the home, the Froessel concealed carry law still would pass muster under intermediate scrutiny because it does advance an important state interest and it is substantially related to that interest. Now, I'd like to draw the court's attention to a Third Circuit case, Drake versus Philco, in which a New Jersey scheme that was similar to the one at hand was upheld in this case, and it survived intermediate scrutiny as well. Now, the state contends that this law, the Froessel concealed carry law, is substantially related to the important interest of public safety at this moment in time.
Why not just have a complete ban on firearms, considering how hard it is to get a carry permit at all?
Well, Your Honor.
No one gets one. I mean, who are the 50 people that got a permit? The
One
police
quarter
officers?
of 1% of the applicants. I figured it out. 1/4 of 1% of the applicants got a carry permit.
And I can confirm that math. I used a calculator.
Great.
In my head.
Well, you're both correct, Your Honors.
But what's the point? What's the point of having a law that allows, it's effectively a de facto ban?
Well, Your Honor, it actually is not a de facto ban. And although 50 out of 20,000 applicants are receiving the permit that is what is in the record, we don't have the facts of the other 19,950 that are in this record. So we don't know if their applications, if they even did have a justifiable need or not. We don't have the facts in that case as to what those other 19,950 applicants, whether or not they just wanted to.
Isn't the point that the criteria that are used must amount to an actual ban if we just look at the numbers alone? It doesn't really matter what the facts are. If we see the results, why isn't that a de facto ban?
It is not a de facto ban because it merely is regulating. The language of the statute is regulating the use of firearms outside of the home itself.
I guess what you're saying is maybe there's 19,950 criminals who applied for firearms and only 50 didn't, and so that's why there's 50, right?
Not necessarily, Your Honor. The 19,950, we don't have the stats on who they are. I'm not suggesting that they were necessarily criminals and that's why they could not obtain it. However, I would like to draw the court's attention to the fact that all homicides committed in public in the state of Froessel were committed with firearms. Now, before the enactment of the Froessel concealed carry law, there were 70,000 firearms in the public sphere in 2007. Now, in 2013, that number has decreased to 10,000 firearms.
Those were legally sold firearms, because that's the only way you could keep track of that.
Yes, Your Honor.
But there's a vast flow in many states of illegal firearms. And so, you don't know how many, for instance, of the 6,000 murders were done with legally acquired firearms as opposed to illegally acquired firearms. We don't know that, do you?
No, Your Honor, we don't know that. However, unfortunately, no law that any legislature pass is completely foolproof. That is understood.
By the way, what level of scrutiny should we use to analyze the burden of the carry law?
Intermediate scrutiny, Your Honor.
So you accept that it's the intermediate scrutiny?
Yes, Your Honor, a form of heightened scrutiny, intermediate scrutiny in this case. We do understand that the state does have to prove beyond a mere rational basis for this enactment of this law. However, the state does satisfy intermediate scrutiny because it does have an important state interest here, which is ensuring the citizens of Froessel's safety, and this law is substantially related to such. If I could just draw back on my point to the fact...
Isn't the core of the Second Amendment, in effect, gutted if only 1/4 of the carry permit people get their permits? No, doesn't that gut the core of the Second Amendment, which is the right to carry arms for self-defense?
No, Your Honor, it does not necessarily gut the language of that, the core of the amendment, excuse me. However, it just places a restriction on it, subject to someone showing a justifiable need.
But is your argument, go ahead.
In terms of the justifiable need requirement, wouldn't you agree that most crime victims, prior to the time that they become a dead crime victim, would never qualify would never be able to meet that justifiable need requirement. Would you agree with that?
Could you repeat that? I'm sorry, Your Honor.
Excuse me?
Could you repeat the question? I'm sorry, Your Honor.
In terms of the justifiable need requirement of the FCCL, wouldn't you agree that, let's say, in excess of 90% of crime victims of violent crime, would never be able to meet the justifiable need requirement until they became victims? And if so, how do you reconcile that with a constitutional right to keep and bear arms in case of confrontation?
Yes, Your Honor. Well, the fact that somebody is just a victim is not necessarily what classifies a justifiable need. Someone could have threats against their lives that could come out of thin air. We don't know exactly what these threats would be. However, just because one does not have to wait until they are a victim of a violent crime to show a justifiable need. There is language in the statute that provides for threats against one's life to pertain to a justifiable need. So there are other avenues of achieving a justifiable need in this case.
What about judges? Do you think judges have a justifiable need? Should they be able to get a permit?
I believe that the important...
You know what trouble is if we were carrying guns.
I believe that the sphere of the public is what is most important in this case. And that is what is most important for the state to reconcile the needs of the public to be safe at large versus one individual. Now, it just depends on whether or not there are threats to somebody's life, whether or not they do show a justifiable need in that case. The state is very concerned about the public safety at large of its citizens here.
In applying intermediate scrutiny, have you really done anything to keep the public safe? You mentioned that the sales of arms went from 70,000 the year the statute was passed to 10,000. But I think we can assume that whenever someone starts talking about passing a gun control law, everyone and their mother goes out and buys a gun. It always spikes right before legislation is enacted. So that's probably why you got to 70,000 in 2007. And the fact that it came down to 10,000 doesn't mean there aren't now a total of 500,000 people out there with guns, right?
Correct, Your Honor. However, the legislature intended to cover what they can at the moment in time. As I said, no piece of legislation is ever foolproof. So it cannot possibly, this is where the state of Froessel decided to start. This is the first and only regulation that Froessel has in place. This is where they felt it was a good starting point. It decreased firearms from 70,000 to 10,000. And basic economic principles suggest that when there's less access to a product, that there will be less use of that product and less people can obtain that product. And that is what is occurring in this case.
Counselor, shouldn't this court balance the extent of the intrusion on the Second Amendment right, which here is tremendous since only 50 people got permits out of, 20,000 applicants? Shouldn't we be balancing the extent of the intrusion with actually the effect and whether it's actually achieving the stated effect of reducing crime? And if it's not really reducing crime and the intrusion on the right is so great, is that really a reasonable way to approach the problem of gun violence?
Well, Your Honor, the form of intermediate scrutiny would look at the law rather than the intrusion in this case. And the law at hand in this case does have a substantial fit. This court has even stated that the fit need not be perfect. It just must be a reasonable fit. And this is a law that the Froessel legislator felt achieved those important public interests of keeping the public safe at this point in time. I see that my time is up.
Got the Second Amendment on the ground that gutting it is reducing crime? Let's assume you're correct that crime has been reduced. Is that a basis for gutting the core of the amendment, Second Amendment?
Your Honor, may I answer your question? I see that my time is up.
When the Chief asks you a question, you can always
You can answer it.
Just wanted to make sure. Thank you, Your Honor. I do not think that it is gutting the core of the Second Amendment. The core of the Second Amendment, as enumerated by this court in the District of Columbia versus Heller, is the right to bear arms in one's home. And the Froessel concealed carry law does not impinge on that whatsoever.
But one more question. If we assume that it is not limited to the home,
yes,
it carries out to the public, does it make a difference whether crime is reduced or not if you're gutting the core? In other words, if the burden guts, that's what scrutiny is, intermediate scrutiny. If it guts the Second Amendment, does it make a difference whether crime is reduced or not?
Well, Your Honor, if the right in District of Columbia were to extend outside of the home, this law would still pass intermediate scrutiny because it still is substantially tied to the important state interest in maintaining public order and achieving that there is less bloodshed and violence on the streets of Froessel. Thank you very much for your time, Your Honors.
Respondent?
Oh, no, we have plaintiff too.
I mean, excuse me, the other petitioner. Are you reserving any time?
Yes, Your Honor. I asked to reserve 1 minute for rebuttal.
Granted.
Thank you. Good afternoon, Chief Justice Irenas, Your Honors. May it please the Court. My name is Kimberly Gay, and I, along with my co-counsel, Catherine DeSalva, represent the State of Froessel, the petitioner on this appeal. The State of Froessel respectfully asks this Court to reverse the decision of the United States Court of Appeals for the 13th Circuit. We ask this Court to hold that the RFRA does not entitle the respondent to a religious exemption from the public accommodation requirement imposed by the FCCL. Your Honors, this case is about the State of Froessel's obligation to its citizens to eradicate discrimination and provide equal access to the public marketplace. The FCCL was enacted in 2007 and makes it unlawful for any person or facility operating a firing range to discriminate against any individual because of race, gender, or in this case, religious affiliation. The FCCL, Section 3, does not impose a substantial burden on the respondent. Any person who violates the FCCL on the basis of race, gender, or religious affiliation will be subject to fines. And in this case, the respondent is not substantially burdened.
Do you think we can glean anything from the fact that the United States Congress in passing Title VII included a religious exemption, but your statute in the state did not?
Your Honor, the FCCL, the nature of this statute is specific to firing ranges. Right now, the State of Froessel is combating a very difficult situation with high crime due to handguns. So this statute was enacted in order to further the public safety of the citizens of Froessel. And this statute does include that anybody who is denied service on the basis of race, religion, or gender will be subject to a fine.
Right. Can you answer my question now?
Your Honor, can you please rephrase the question?
Yeah, what I'm saying is the United States Congress apparently thought it was necessary for First Amendment purposes in its most comprehensive anti-discrimination statute, Title VII, to include an exemption for religious practices. Your statute does not. What should we draw from that, if anything?
Your Honor, you are correct that Title VII does apply to religion. The State of Froessel is not trying to deny anyone religion. So we are trying to advance religious freedom across the board.
The problem in real world terms. If you require this person of a certain faith who's running the firearms range to have Satanists there who he doesn't think for strong religious reasons he should be teaching to shoot firearms, he may well become, and we have to assume he will become, the Satanist firing range headquarters in the state. Every Satanist in the state is going to go there, and he's going to find himself with a clientele that may be 30, 40, 50, 70% Satanists. And he says, as a religious person, I don't want that in my business. Why should he have to have it?
Your Honor, we are not advocating that the respondent not follow his own religious beliefs. We are not trying to take that away from him. We are simply stating that if he is going to prohibit or refuse service to any individuals on those grounds, then he will need to pay a fine. We are not taking
$15,000.
Yes, Your Honor. However, it is the respondent's choice. He is choosing to operate his firing range, so if he chooses not to operate the firing range, then he will be compelled to pay the fine.
Counsel, let me just shift a little bit. It's not disputed that Mr. Liu holds a genuine religious belief that he should not enter commercial transactions with a Satanist. That's not disputed, that he has a genuine religious belief, correct? That's not a disputed fact.
Yes, Your Honor.
Okay. Why doesn't Hobby Lobby why doesn't that answer the question? Why haven't we, in effect, already decided in the Hobby Lobby case that a genuinely held religious belief will be accommodated? Why doesn't that case sort of end the discussion?
Your Honor, Hobby Lobby specifically decided that religious exemptions should not be extended to cases of discrimination. And in this case, the respondent has discriminated against Sigmund Young, and there's no telling who else he may have discriminated against. The state of Froessel's concern is to ensure that no one else is put into the position that Sigmund Young was placed in. We cannot allow our citizens to discriminate, but at the same time,
an argument that Hobby Lobby, in fact, Hobby Lobby was discriminating against women employees?
Yes, Your Honor. No, Your Honor. They were discriminating.
There was an establishment clause issue there, too.
Yes, Your Honor. To answer Justice Abraham's question, the Hobby Lobby, although it was specific to, it did give a religious exemption. However, it was not discrimination. In this case, it is discrimination because he is denying service to other individuals who don't practice the same way he does. Again, he does have a choice, and however, if he chooses to operate the firing range, he will need to pay a fine.
How would you respond to the question that the respondent is being punished because no other firing range chose to open in the city? Why is it his problem to overcome that burden? I mean, is anyone stopping anyone else from opening a firing range in the city, number one? And number two, this is 2014. The nearest firing range is 120 miles away. Is that great a burden for somebody to drive 2 hours to get a license, to get the training requirement that he needs to satisfy a once-in-a-lifetime requirement?
People commute to work 120 miles every day.
Justice Kachowski, if I may answer Chief Justice Irina's question about the Establishment Clause, that does play a factor into this case because the Establishment Clause prohibits shifting burdens from one party to another, and that's exactly what we have in this case. The respondent may have a burden. However, it would not be proper for the state of Froessel to shift that burden onto anyone else because of his religious beliefs.
Judge Kachowski's point was that it's not much of a burden. I mean, going to that was his point. Why is it much of a burden to have to travel 2 hours in an automobile?
Justice Kachowski, that does bring me to my second point, that the state of Froessel does satisfy strict scrutiny because there is a compelling interest, and the FCCL is the least restrictive means in furthering that compelling interest.
Really? Why don't you give the Satanists travel vouchers to go 120 miles?
Your Honor, right now the state of Froessel is dealing with a big issue of crime. We are trying to combat the issue of homicides due to handguns, and right now the respondent's firing range is the only firing range in the city.
Don't the police have firing ranges?
Your Honor, police do have firing ranges. However,
I'm not sure what the practices are of the police and their firing ranges, but the state of Froessel only has one firing range to service all of the individuals in the state. It is our responsibility to ensure that we are protecting them and ensuring their public safety. And if the respondent is denying service to any individuals...
Why can't the respondent use the police range?
Your Honor, that may be something that we can look to in the future. However, now we only have one firing range, and that is the firing range.
Public firing range. Oh, it's open to the public.
Yes, Your Honor.
But doesn't the least restrictive means prong of the test perhaps suggest that the government has an obligation to either allow people into the police firing range or create its own public firing range in order to create the least restrictive means, so as not to substantially burden somebody's free exercise of their religion?
Your Honor, the state cannot be responsible for building additional facilities or providing another way for the sole purpose of accommodating the respondent. We do have a concern for all of the individuals living in the state of Froessel, and it would not be proper for us to offer this religious exemption because he may feel burdened if it's at the expense of other individuals in the state of Froessel.
Back to the question. You've got to use the least restrictive means. Seems to me you could have travel vouchers, you could have tax waivers for businesses that want to set up a firing range, you could have special classes that you could teach people. There's all kinds of ways other than requiring this gentleman to either pay what may be, we don't know from the record, a business-ruining fine or compromise his religion. How is it least restrictive in the world of possibilities?
Your Honor, it is the least restrictive means because this is the only firing range. And the state of Froessel should not have to take on the burden.
Gotham, it's not the only firing range.
Correct. It is the only firing range in the city of Gotham. And the state should not have to take the burden of creating these additional firing ranges because the respondent feels burdened. Even though...
Why not? Isn't that what least restrictive means? That the state must take on that additional burden?
Your Honor, the state cannot take on the additional burden and allow the respondent to continue discriminating against other individuals. We are trying to ensure that everyone is given the same treatment and that no one is being discriminated. And we cannot do that. We cannot allow him to have this religious exemption and shift that burden to other individuals.
Every person who is accommodated by REFRA, in a sense, shifts the burden to somebody else to some degree. It's inherent in the operation. If you didn't allow the burden to be shifted at least a little bit, am I correct? REFRA couldn't function. So by definition, if you accommodate somebody under REFRA, somebody else bears a burden, but the state should minimize that burden. And that's what we really mean when we say the least restrictive alternative. We're trying to minimize the burden on others. Aren't there a huge variety of ways
Your Honor,
the state could minimize the burden for the Satanists?
Yes, Your Honor, it is the state's concern. We do not want to allow other people to carry a burden. However, the respondent is shifting a substantial burden onto other individuals.
Only because the state is not taking the various alternatives it has to deal with the issue.
But let me put it this way. In Hobby Lobby, the women employees of Hobby Lobby had to go out and pay for their own birth control. That burden was placed upon them in order to accommodate Hobby Lobby's religious belief. In this case, you have the owner of the firing range burdening the Satanists who are now going to have to travel 120 miles. Is the additional burden on women to buy their own birth control when they work for Hobby Lobby less onerous than the 120 miles that the Satanists are going to have to travel?
Your Honor, no. The burden that is being shifted onto Sigmund Young and to other individuals is a substantial burden. It would not be proper for the state to take away the burden from the respondent and shift that burden onto other individuals.
But assuming we said that you're going to shift the burden, aren't there things the state could do to ease that burden?
Your Honor, I see my time is up. May I conclude?
You can answer that question. Isn't there a variety of things the state could do to ease the burden on the Satanists, assuming we said that RFRA did apply and Mr. Liu was within his rights to do what he did? Isn't there ways the state could ease the burden on the Satanists? A variety of ways.
Your Honor, it is the state's position that we are looking to ease the burden on everyone, not just one individual such as the respondent. It's our concern to ensure equality for the entire state of Froessel, and it must not be at the expense of one individual. The state of Froessel is a very religiously diverse community. We do need to look after every single one of those beliefs. And if one individual is discriminating against another's, that's not something that we can tolerate, and we do need to ensure that everyone is being treated equally. Thank you.
Thank you. Thank you.
May I approve, John?
Yes, you may. You may proceed.
Thank you. Good afternoon, Chief Justice, Your Honors. May it please the Court. My name is Trevon Luncheon, and I, along with my co-counsel, Nicole Mosey, represent Mr. Jeff Liu, the respondent on this appeal. We ask that this Court uphold the decision of the Court of Appeals for the 13th Circuit and hold that the Froessel Concealed Carry Law, FCCL, violates the Second Amendment for two reasons. The FCCL imposes a burden on Mr. Liu's Second Amendment right to bear arms. And the second reason is that the FCCL does not pass intermediate scrutiny. Your Honors, this issue concerns the right of Froessel to pass a law that restricts or virtually prohibits the right of citizens to carry arms in public.
Can I ask you this? If Froessel passed a law saying that nobody could carry arms in public, nobody could do it, would that burden the Second Amendment? Would that gut the core of the Second Amendment?
Yes, it would, Chief Justice. The right of the Second Amendment gives us the right to carry and bear arms for self-defense. It was this court in Heller that said the right to keep and bear arms is for self-defense in case of confrontation.
But we were writing in a home carrying case, right? We were talking about the home. So we are now at a blank slate, are we not? We haven't said anything about carrying guns outside the home.
Justice Kogan, we are not at a blank slate. The only time that home was mentioned in that case, Heller, was when it was talking about the DC statute, and it was struck down. In Heller, this court said that the right to keep and bear arms is for self-defense in case of confrontation, and confrontation happens inside and outside of the home.
Counselor, are you arguing that any limitation on the Second Amendment right to bear arms outside the home would be unconstitutional? Or would you be okay with the justifiable need requirement if a reasonable number of applicants actually were deemed to have a justifiable need? Would you find it a reasonable regulation that would pass intermediate scrutiny if, in fact, 50% of the applicants who said they had a justifiable need were permitted to get a license?
Yes, Justice Abraham. It would pass intermediate scrutiny if there was that substantial link between the law and what we are seeing in terms of the handgun violence. If there was a substantial decrease, because it has to be substantial, if there was a substantial decrease in the number of handgun deaths, then it might pass intermediate scrutiny.
Okay, but then that brings me back to my question of how do we know that 19,950 of the applicants for the permit, in fact, didn't have criminal records, and that's why they were denied? We don't know that, right, on this record?
No, Justice Kogan, we do not know exactly why any of the applicants were denied, but it is hard to believe that only 1 out of every 400 applicants have criminal records. And there's no problem with the regulation of handguns. If you are mentally ill or if you are a felon, you should not have a handgun. We have no problem with that. Those are long-standing regulatory measures which we have no problem with. But
you accept that a permitting system does not per se violate the Second Amendment? That if a state adopts a permitting system for carrying handguns, that per se, just the existence of that, does not automatically gut the Second Amendment?
No, Justice, no, Chief Justice. It does not per se gut it if it is a permitting system.
So your whole argument comes down to the fact that only 50 people out of the 20,000 got permits. That's the core of your argument.
Yes, Chief Justice. The argument is that it acts as a prohibition or a near prohibition on the carrying of weapons because only 1 out of every 400 individuals actually get accepted.
What if 500 instead of 50 got permits? 500 out of the 20,000. 500 people got permits and the other 19, whatever it is, 19,500 didn't get. Would that be okay?
Which I think would be 2.5%, but I won't swear.
But 500 is a lot of people, so...
No, Chief Justice, I would not swear to it because it would still depend on the circumstances. If we get into just the numbers, then this court might get into speculation. But we have to also look at what effects this has on the law and the city of Gotham.
But isn't that the problem with this court getting involved in any kind of analysis of the statistics? That's not really our job. And shouldn't we just defer to the legislature on that? That's their job, to look at the facts and figure out what the regulatory scheme precisely should be. If, in fact, we've decided that some regulatory scheme is constitutional, aren't we done? Shouldn't we uphold the law? Even if we remand it for a reconsideration of how it's applied to the facts, aren't we finished here and we've decided that the law is constitutional?
No, Justice Abraham, we would not be finished here because even if we decide that there are factors that make it necessary, even if we decide there are factors that allow persons to carry guns, we have to look at how many persons are given those guns. The FCCL acts as a prohibition because it obliterates the Second Amendment, Your Honors, because it was stated in Heller that if too few persons are allowed to carry out their Second Amendment right, it acts as an obliteration. And this has been upheld by other courts, namely Peruta versus County of San Diego, just this year.
Let me ask you another question. You've already told us that some permitting schemes would be acceptable to you, for example, one that excludes criminals or the mentally ill. What about one that excludes people who just have no need for a gun at all. What about the justifiable reason component of the statute?
Justice Corrigan, that would be a good idea. If we can show that persons have no need for a gun, they should not be able to get one.
Okay, then let me rephrase my hypothetical to you. The 19,950 people are not just people who are criminals or mentally ill. They're people who, in their application, just showed no reason to have a gun carrying around on the street. According to you, that would be legal, and it seems to me that's plausibly what happened here. I mean, how many people can demonstrate some need to carry a gun around on the street?
Justice Corrigan, it should be more than 1 in every 400, and including the respondent, Jeff Liu. He has a need that was denied by the superintendent.
Yes, so, but I think my fellow justice's point was, if that's the problem, that your guy and only your guy in fact has a need, we could uphold the statute and send it back for a determination of whether it was arbitrarily applied to your client in that particular instance. In fact, that the protection against your client from arbitrary action might not even require constitutional intervention. It may be that a state court could go ahead and decide that the action was arbitrary. Why do you need us?
Justice Corrigan, this court has to decide it because we have to my second point, we have to look at the level of scrutiny. The intermediate scrutiny level says that there must be a substantial relationship between the means and the end. The means being the FCCL, the end being the reduction in handgun violence. And we do not see that in the state of Froessel.
Well, they've certainly slowed the rate of increase of violence, have they not? The rate of increase was cut off once this statute was passed. They've now capped at 6,000 shootings, and that's where it seems to be staying. So that part worked, right?
Yes, Justice Corrigan, there has been a flatlining for the past 6 years. This statute was instituted in 2007. From then, as we said earlier, the number of handgun purchases has decreased from 70,000 to 10,000. That means it's 1/7 of what it was. And we see a flatlining of the number of handgun deaths. By now, within these 6 years, we should have seen a decrease, a substantial decrease, not necessarily to 1/7 to be exact as the handguns purchased, but we should have seen a decrease.
So in other words, the difference between what you've called flatlining as opposed to declining numbers is what renders the statute unconstitutional?
Not entirely, Justice Corrigan. There should be some substantial relationship, but we cannot only say that if there is a decline, that it is due to the FCCL. There are other statistics that are not in the record that the state does not know. They do not know how many guns come in illegally. They do not know how other persons have gotten guns. And in such a crime-ridden society, the reason that it most likely flatlined is because those who need guns do not have them. So they cannot defend themselves when they need to, Your Honors.
You're suggesting there would be fewer shootings if more people carried guns? Is that your argument? The more people we let carry guns around is going to reduce the number of shootings?
Chief Justice? Yes, Chief Justice. If there is a need for the gun for someone to defend themselves, and they have proved that need, then when that need arises, they will be able to defend themselves. So that our clients do not only, we do not only realize the needs of our clients after they are dead from the shooting, which they could have avoided if they could have defended themselves. We are not advocating for everyone to have the right to carry a weapon. We still have restrictions, but those who show a need for it, like my client, Mr. Jeff Liu, should be able to carry. And this law, it acts as it only purports to be a permitting scheme, but it acts as a prohibition because of that low number, Your Honors.
However, Counselor, practically speaking, you're arguing that somehow the agency that we defer to make the determination about justifiable need is wrong, and that we should make a different determination. Are you asking for the court to make a determination as to each application? Or if we don't give deference to the agency with expertise to make that determination, how could we possibly implement what you're arguing for?
Justice Abraham, the superintendent of police is the one who makes that determination. We already see a problem with the police force because their response time is 10 times longer than the average. So we can already see that there is a problem. And we are only asking for this law to be struck down because it is unconstitutional. If another law, if the FCCL was restructured and brought again to enable those who have the need to get a gun, then we can still allow the superintendent of police to institute it.
Counsel, at root, since you concede that a licensing system can be okay, aren't you really asking us to define justifiable need? And is that our role, to sit here and try to define what the phrase justifiable need means? Is that what you're really asking us to do?
Your Honor, I see my time is up. May I answer your question?
You can answer that question.
Thank you, Chief Justice. Chief Justice, we are not asking you to define what a justifiable need is, but we are asking you to strike down this law because it is unconstitutional, because my client is being burdened. Our client is being burdened by this law.
But if the superintendent of police gave permits to 60% of the people who asked, then you would concede it wasn't that it was not unconstitutional, right?
Yes, Chief Justice. Most likely it would not be unconstitutional if we can also prove that it was a substantial means-end link. Your Honors, my client has already been attacked. He has already lost a loved one, and we ask that you uphold the decision of the 13th Circuit.
Okay.
Thank you.
Thank you very much. You may proceed.
Good afternoon, Chief Justice Irenas, Your Honors. May it please the Court, my name is Nicole Mosey, and I, along with my co-counsel, Trayvon Luncheon, represent the respondent on this appeal. Your Honors, this case is about a survivor of not one, but two life-threatening events whose religious beliefs were unjustly trumped by his very own state government. We ask this Court to uphold the decision of the United States Court of Appeals for the 13th Circuit, finding the Froessel Concealed Carry Law, Section 3, unconstitutional for the following reasons. First, the FCCL Section 3 violates the Religious Freedom Restoration Act because Mr. Liu has sincerely held religious belief that is protected by the RFRA. Second, the state does not qualify for an exemption under the RFRA because it has generalized interest and has not employed the least restrictive means of furthering that interest. Your Honors, Mr. Liu has a sincerely held religious belief that is burdened by the FCCL Section 3 provision and its subsequent monetary fine because it forces him to conduct his business against his religious faith.
You know, it strikes me that Satanists are an easy target, but what do you do with the next gun range owner who says, my religion prohibits me from dealing with homosexuals? What do we do then?
Your Honor, we defer to the RFRA because the RFRA gives us guidelines or elements that must be defined when a claimant believes that their religious exercise or beliefs are substantially burdened and by a state government. So under the RFRA...
They allow him not to serve homosexuals at his range because he says it violates his religious beliefs?
Your Honor, Colgan, as long as that claimant can prove that his religious beliefs have been substantially burdened by the government, and it is a religious belief that is more than a philosophical way of life, and that religious belief is sincerely held by that claimant, then yes.
Well, let me take it a step further. Let's assume had a person that said that letting a woman go to a shooting range violated his religion. And he had the right to exclude all women from shooting at his range.
Once again,
would that be permitted? And let's assume it's a sincerely held belief.
Let me assure you, there are such religions.
Oh yeah, that was not a theoretical question. And he said, "That's my religion. That's my religion, and I sincerely believe it." And everybody concedes he sincerely believes it. Should we let RFRA just bar all women from getting this qualification?
Once again, Chief Justice Irenas, the RFRA was established to protect the religious exercise of others. And in that particular instance, if those elements were satisfied by that claimant, yes, they would have a claim. However, here with Mr. Liu has been substantially burdened. He is a devout Christian who sincerely interprets his faith in the way that he sees most reasonable, which is the fact that he is not allowed to conduct business with people who oppose his religious faith. And under the case of the United States...
That's a pretty minor, though, in the end of the day, that's a pretty minor intrusion on the full scope of his religious beliefs.
Chief Justice Irenas, according to a case that this court reviewed, United States versus Ballard from 1944, this court held that when a claimant does have a sincerely held religious belief, that the court in the state is prohibited from questioning the falsity or the truth of that religious belief. And that belief does not need to be held by other members of that religious sect. It is only important to that particular claimant. So here with Mr. Liu, he is conducting his business in a way that he sees most appropriate in accordance with his religious beliefs with Christianity. And he interprets his faith in a way that he deems that is appropriate. The beliefs that he holds are the concern between him and his higher deity. It is not the concern for us to question his religious beliefs or sincerity of those beliefs. And it does not matter whether other Christians in his group hold the same interpretation as Mr. Liu.
I think the record supports all of that, and I think that's true. The question, though, is there any flexibility? Yes, he is sincere. He has this belief. It's a bona fide religious belief. But is it as absolute as you say, where if the religion excludes whole classes of people against whom discrimination is prohibited, whether under the First Amendment or the 14th Amendment, the religion concern trumps everything else in the Constitution all the time?
Justice Colgan, the RFRA does grant an exemption under this statute that says if a state government can prove that it has a compelling interest and furthermore has employed the least restrictive means of furthering that interest, then they may be granted an exemption.
Is there an Establishment Clause problem by us upholding that? Would that run afoul of the Establishment Clause of the First Amendment?
Chief Justice Irenas, there is not an Establishment Clause problem. It is true that the Establishment Clause does refer to burden shifting in essence. However, this court in Burrell versus Hobby Lobby decided this year, stated that when you are dealing with or relieving one religious group or person of some sort of accommodation, that burden almost inevitably always transfers to another place in society, to another group.
So you're not concerned that if, for example, your client's religious beliefs prohibited him from serving Jews in his place of business, that we might, by upholding his right to do that, be demonstrating a favoritism towards Christians over Jews?
And hence an Establishment Clause problem.
Right.
Justice Colgan, there would not be as you have termed, favoritism if we grant Mr. Liu this exemption, primarily because in addition to the public accommodation mandate, if it is violated, the FCCL imposes a $15,000 penalty on the person who has allegedly violated the
Let's look at that $15,000 penalty. Why do you argue that that's a substantial burden when in other cases, for example, in Bob Jones, the court found that revoking tax-exempt status was not a substantial burden?
And that was millions.
Yeah, that was a lot of money in
This is
Bob
just
Jones' case.
$15,000. What makes this so substantial? He can plan for it. He knows that this is the law. He can work around it in his business. Doesn't sound like a lot of money for a business.
You are correct, Justice Abrahams, as in referring to Bob Jones University and the amount of money that was in question with the penalty there. However, it's important to note with the FCCL statute and the $15,000, at first the statute was flawed in a sense because it does not describe how the $15,000 is to be applied to a person. We do not know based on the facts whether that is applied every time a person
That could be,
violates.
couldn't the 15,000 be multiplied every time a new Satanist applied to go to the shooting range? It'd be another $15,000 fine. So it may not be just 15,000, right? It could be multiple 15,000.
That is correct, Chief Justice Arenas. But furthermore, we also do not have facts that allude to Mr. Liu's financial state. But more importantly, no matter how big of a fine or how small of a fine could be, this is a constitutional right that is violated. The religious exercise, the freedom of interpretation, the freedom of belief, and the value of a constitutional right is priceless. It does not matter how large the monetary fine may be. But in this instance, it could be that since Mr. Liu is a small business owner,
what's the constitutional right? The right to go to the shooting range?
No, Chief Justice, I mean, it's the constitutional right to exercise one's religion, is what I was referring to.
Deny the Satanist admission to his shooting range.
Would that constitutional right be any less protectable if Mr. Liu decided he wouldn't do business with anyone but Christians? Let's just say we expanded it. So it wasn't just Satanists, but it was Jews, it was Muslims, it was Zen Buddhists, it was Hindus. Would your argument be the same, or would it change? Would you have a problem with that, or do you still think it's protected here and he should get that exemption?
Chief Justice Abraham, as long as Mr. Liu has demonstrated that his religious beliefs are substantially burdened and that is his religious belief, that's not a philosophical way of life, and he sincerely believes that, then the argument holds true in those other instances. But it's also important to remember that the state has to prove that it has a compelling interest and has employed the least restrictive means.
Is it your position that we shouldn't look at the size of the burden? That no matter what the burden is, we're required to let him do what he wants to do?
What if it was $10 instead of $15,000?
Your Honor, Colgan, like I mentioned earlier, a constitutional right, which is the main issue here, the freedom to exercise one's religion, is priceless.
So $10 would still be unconstitutional.
But his right to exercise his religion would not be prohibited. He would still have it, and that you're then implicitly arguing that $10 would be a substantial burden because he still has his right to exercise his religion. He would just have to pay $10. Would that be substantial?
Justice Abraham, it may be substantial in the eyes of Mr. Liu. Mr. Liu, this is his main, the firing range of peacekeeper is his main this is the way he makes a living. It's his livelihood. This firing range, he operates in accordance with what he deems as most appropriate, which is his religious beliefs of Christianity. The state of Froessel has generalized interest in public safety and equality. And those are important interests. However, this court determined in Hobby Lobby that when a state is articulating its interest in regards to an RFIR exemption, it must state that interest with particularity. And here the state has failed to do so. It has failed to state how their interest in public safety, even though Gotham does have a history a rather shocking history of criminal occurrences, it has failed to state how this specific provision of the FCCL furthers their interest in decreasing the amount of violence.
Here's what bothers me about your analysis. You seem to be reading out the words substantial from substantial burden. Once we get down to $10 is enough, and anything that your client thinks is a burden is enough, then we might as well get rid of the word substantial in front of substantial burden and just say it like it is, which is that if the citizen believes that there has been any burden placed on him, then the requirement is unconstitutional. But we haven't said that. We've said substantial burden. What meaning does substantial have? It can't just be whatever a citizen thinks it means.
Your Honor, Kogan.
Maybe we should go ahead and say any burden is enough of a burden.
Your Honor, Kogan, the substantial burden definition and its interpretation does vary from case to case depending upon the claimant. However, in the case here, Mr. Liu does interpret that the provision in the $15,000 penalty to be substantial upon him in conducting his business. Also to allude, Justice Kogan, like you mentioned earlier, the Title VII federal statute does grant a religious exemption, which furthermore points that the FCCL is flawed in its construction of this public accommodation and the subsequent fine that follows with it.
Counsel, even in Froessel, the Satanists have made a very good case for the right to get a carry permit. You know the history of the various threats that have been made against them. They've made even where only 50 are granted, they've made a pretty good case. By keeping them from getting the training certificate they need, aren't you burdening their Second Amendment right? Aren't you putting a burden on their Second Amendment right, which would be a substantial burden that we would not tolerate?
Chief Justice Irenas, we're not significantly burdening their Second Amendment right because the state has not proved that it has employed the least restrictive means. Right now, Mr. Liu is the only firing range within the city of Gotham. However, unlike the petitioner mentioned, there are 5 other firing ranges within the state. The state could create its own firing ranges, and as Justice Kogan offered earlier, they could offer travel vouchers, provide transportation, provide different levels of classes, and maybe even tax waivers for those who participate under the FCCL. Your Honors, Mr. Liu does have a constitutional claim. The government wants to challenge his livelihood. Once again, he's presented with the Hobson choice of violating his religious beliefs or allowing his business to be penalized because of its operation and how it is operated. Mr. Liu has a constitutional right, and his religious beliefs cannot be trumped by his state government. Thank you.
Thank you very much.
Chief Justice Irenas, Your Honors, my adversary seems to rely heavily on the number of people who have received permits under the Froessel concealed carry law and seems to suggest that this court engage in a statistical analysis in scrutinizing the Froessel concealed carry law. However, the state would just like to remind the court that as lower courts have ruled and as this court has engaged in prior, the proper level in analyzing the public's interest in public safety through the Froessel concealed carry law is intermediate scrutiny. Thank you, Your Honors.
Your Honors, the respondent is incorrect that the state is forcing the respondent to ignore his religious beliefs. The state is not questioning his beliefs. However, the state will not be able to serve the public if we allow individuals to discriminate against others. We must eliminate discrimination in all forms and promote equal access to all. Thank you.
Thank you very much. I guess we're going to reserve, and you'll
hear from us shortly.
You'll hear from us shortly. Thank you very much.
Thank you.
Thank you.
You can go ahead. I'm a little slow.
How much time do we have? Not sure yet.
Hi, everyone. Oh, sorry. The judges are about to come back, so if everyone could please take their seats.
oyez. I will say, oyez, oyez. Before this honorable court, draw near and you shall be heard. God bless the United States of America and this honorable court. Certainly I agree with the God bless part. Everyone, please be seated. Well, let me open the proceedings by saying, first of all, how pleased all of the judges were at the high quality of the arguments. I mean, we listen, at least the two of us that are judges, we listen to arguments almost every day or every week. And you all did yourselves proud for the quality of the arguments you gave us. And our decision was very difficult and very, very close. Unfortunately, we have to pick both a winning team and a best oralist. And we have no choice. We can't give it to all of you, although we might have liked to. The winning team, by very close, and remember, it's not on the merits. The winning team on the quality of the argument are the respondents team, Trayvon Luncione, is that right? Luncione, and Nicole Mosey. So congratulations. And the best oralist, again, or the fact that we had to pick a winner should not be in derogation or denigration of any of the other three. But we selected Nicole Mosey as the best oralist. Now I would ask my fellow judges to for their particular comments. I'm going to start with Judge Abraham.
Wow. Congratulations to everybody who went through this, and particularly to the 4 final round finalists who all did a really excellent job. And I want to thank you for just taking that risk this summer and putting your names in, and then all of the hard work that followed. So just a round of applause for all 4 of you and everybody. And before I give a little bit of feedback, I also wanted to really thank my fellow justices up here, Judge Kogan, Judge Irenas, and Mr. Kachalski, for putting in the time on a Sunday, volunteering to come, and with all of your experience and expertise, giving what you've learned back to the students, and we all really appreciate that. Okay, I'm Susan Abraham. I'm the Moot Court Faculty Advisor. I'm sure most of you know. I was thrilled to see so much talent here today, and I just want to say you all did a really great job. I thought, oral argument before the U.S. Supreme Court is a really different thing than oral argument before the appellate court or argument before the trial court. And one of the things that is difficult before the U.S. Supreme Court is that there's actually no precedent that you can argue that we have to follow except our own. And so, you're stuck arguing circuit court cases to the U.S. Supreme Court that we say, okay, that's interesting. Now what should we do? So just one suggestion is when you are pushing a circuit court decision as supporting your argument, you might acknowledge, of course, the court doesn't have to follow this. This is what the Fourth Circuit did. This is what the Fifth Circuit did. But it's instructive because, or we think it's persuasive because, and then argue about why it's right, not just that they decided it, but why we should follow them, because obviously there's a circuit split or you wouldn't be here, right? So just because there's a case doesn't mean it's going to persuade us. You have to persuade us. And then along with that is just don't forget the law. There are a lot of cases here, and you guys all cited, I heard a lot of Hobby Lobby, and I heard a lot of one or two other cases. I could have heard a bit more. This is the U.S. Supreme Court, and there are reasons why, comparing it to another intermediate scrutiny case, perhaps, where the court found something similar, or distinguishing it from another. Don't forget, have all of your cases there in your arsenal when you're making an argument to use it for authority. I thought you had a lot of facts that you had to master, and you did a really good job mastering them. I would just say also don't forget to bring that law in, not by itself, but after you make your argument as authority to either distinguish or support your case. Okay, Catherine DeSalvo, I thought you had an incredibly trustworthy, credible manner up there. You came across confident but not arrogant. You had a warmth. You engaged the court. And I thought that that goes a really long way. I would be careful when you said the three reasons that you gave was that this court found in Heller that the Second Amendment was confined to the home was your first reason. And I would just warn you to be careful. You don't want to give the court a reason to jump right in and interrupt you and make a claim that's a little too grandiose right in the beginning and then open yourself up to attack by the court. So just maybe in your first statement, if you're saying what the court says, especially since we're the court who wrote that decision, in theory, in the fictional world of Froessel, just be careful not to overstate in your introduction or your summary of your argument so that you're not going to be interrupted before you're ready. Otherwise, I thought you did a really good job, and I thought your rebuttal was admirably short, to the point, focused on one issue, and that's exactly what rebuttal should be. It's hard to do a good rebuttal, and I think you did one. Okay, Ms. Gay, also great manner, presence. You were very calm, despite the constant questions. You got interrupted early on.
Hard questions, very hard questions.
Really hard questions. I mean, sometimes it's just there was no answer. You just have to come up with one. And you held your ground. You stayed calm. You never looked rattled. You knew the facts. You knew the law. And I also thought your rebuttal was brief and to the point, and that's exactly what rebuttal should be. Sometimes it's the hardest questions are the ones that we really don't have an answer for, and you just have to be prepared with something to say. The question about, couldn't the government take up some of that burden? Couldn't the government open a firing range? That's a hard question. And I think you had a little trouble with it during the argument, but I have to say I was really impressed with the way you closed your argument by saying the government needs to kind of balance the burdens on everyone and ease the burdens on everyone. And there is no one party that the government can favor, and that's what the government's trying to do here. And I thought that was a really good way to close your argument and very powerful. Okay, Mr. Luncheon, I thought that you had a very thoughtful, you slowed down the argument by pauses where you actually gathered your thoughts, and then because you paused before each statement, it gave each statement some power. And I think that, that can work. A lot of people are afraid to pause and take a breath, and I think it can be a very powerful way to get your arguments together. I think that you had a combination of seriousness and authority with kind of warmth and connection with the bench that I thought really worked. And, you had a tough job there when you were being asked about whether you would concede whether some regulatory system could be upheld. And once you concede that, where do you go with your argument? And I think that the respondent side on these issues is actually, there's not like an easy answer on this side. So I just thought that you held your ground. You absolutely believed in your argument, and you kept going, and it was tough, and you were very persuasive. Incredible style and strength. And Ms. Mosey, I thought that you really combined knowing the law, knowing the facts, together with a passion for your position. And at the beginning, I didn't see the passion quite so much. Maybe you were just a little nervous, or you were getting started and you were laying out the pieces of your argument. I liked the way you started. But then you really worked into that passion, and you became very persuasive, and you really believed in your argument. And you also responded directly to questions, which the judges always want to hear. If you don't know the answer, you still need to start with a yes or a no, and then explain why. And I think you managed to do that, even though you were also asked some very, very tough questions. I thought you handled them very well. So I just want to congratulate all of you on doing a great job, and I look forward to working with you.
Thank you. Justice Kachalski.
There isn't much I can add to what Justice Abrams said. I can concur in that. I was quite impressed with all of the arguments. I understand you all just finished your first years. You're starting your second year. And to stand up and argue a case of this complexity before an audience and before judges, and to answer questions, some of which, as Justice Abrams pointed out, there really is no good answer to. I think you all did a great job, and congratulations to all of you, and I'm sure all of you will do just tremendous in your careers and in school. I wish you all the best of luck.
Justice Kogan.
You'll find the comments keep getting shorter as you go down the line.
After Justice Abraham, yes.
Yeah.
Oh, he says I talk too much?
No, I didn't say that. You covered it all.
I do want to put what I'm about to say in context, which is that I was really pleased with everyone. I thought everybody did a really good job. It's hard to believe that you're rising second years at this stage of your careers. You can appear in front of me, all four of you, anytime you want to. You're already better than most of the lawyers that I see. What I'm going to say now, I say that first because what I'm going to say now are the particular criticisms that I noticed, and I give them to you so you can think about them, and if you agree with them, you can use them, but I don't want you to take them out of context because I was really satisfied with what everybody did. I think the most important thing, and everybody needed some improvement on this to varying degrees, is you've got to answer the court's question. You cannot not answer. And yes or no is the only way to answer 90% of the time. Occasionally, you can get away with, it depends. But it's got to be a 1 or 2 word answer. And if it's it depends, then you've got to follow it up very quickly with what the factors are that you're depending on. I asked you the hardest questions. And that was easy for me because you had the toughest position. But the one that you were most frustrated with was, how do we compare the burden on the women in Hobby Lobby when the employer is told you don't have to pay for contraception with the burden on the people here? And I don't know if there's a good answer or not, but it was not an illogical question. And that's something you need to go, here's the difference. And as Justice Abraham was saying, you have to come up with the authority. You have to be ready with the authority and go, here, this is more like this case than Hobby Lobby. And you have to have something to countervail it. But I'm not sure there is a great answer to that question, so I don't hold it against you that you couldn't come up with the greatest answer ever. I wrote down for yours that you made some reference to violence and bloodshed. And I thought Mr. Luncheon also did something about what I call plucking the heartstrings, which is an overstatement. None of you did that. But I will tell you, my experiences in appellate courts, you're dealing with weighty issues. People are hurt. People are killed. The appellate courts know that. It kind of washes out in the mix. You got to remember you're not talking to a jury. I mean, I was sitting on the Ninth Circuit about a year ago, and a lawyer started his argument by playing playing an audio tape of the police break-in, which was the basis of the Section 1983 action he was bringing, and the people are screaming and there's children crying, and it sounded horrible, and we couldn't care less. We assumed going in that it was horrible. That's why he was there. We knew that. And to take up argument time by even mentioning the words, I think, isn't really necessary. I liked your pausing. I think it's really good. There's a tremendous tendency to rapid fire, and it can backfire on you. It's better to take a moment and think. Having said that, when I asked you, aren't we writing on a blank slate? That was a one-word answer. Yes, you are. There are lower court cases that touch on this, but you are not bound by Heller. You have a blank slate as to this issue. You had a very good answer to the question, well, are you saying that more guns means less shooting? You said, yes, that's what it means. Because that's the position that people who were taking your position take. The only thing that was wrong with your delivery was you kind of smiled, like you didn't really believe that. Now, I understand that you have all had now going on your 6th year of socialist training camp, but let me assure you that there are a number of people out there who sincerely believe that more guns means less shooting. That's why you can walk around without any permit at all in Arizona and carry a gun. And that's what they believe, and that's got to be the position that you adhere to. And particularly the owner of a gun range or the guy who wants a gun, he's going to believe in that. The last thing I want to mention to Ms. Mosey is I asked you a very hard question. What is a substantial burden, right? And the fact of the matter is, in my view, and the reason I got invited to this is because I wrote on this recently, in my view, substantial is no longer part of the burden. As a practical matter, any impairment is deemed substantial. And I think at some point someone's going to come out and say it, and the Supreme Court is a good place to say it, to say, here's how you've applied it in practice. So there may be a different meaning to the word substantial than we always use in everyday English. It may, in fact, mean a much lower standard than substantial might imply. And I think the court's either got to move in that direction in terms of language, or it has to really start redefining what it has defined as substantial burden. So, the thing about being a lawyer is you can't be afraid. You have to come out and say it. More guns, less shooting. Substantial doesn't mean much. It really doesn't. Look at your case law, Judge. You can see it. So, like I said, I was really pleased, and it was a pleasure for me to watch you all come to court anytime.
Thank you, Justice Kogan. I would like to start by thanking the drafters of the fact pattern. I think it was a terrific fact pattern. It was well prepared, well thought through, and made for an exciting competition. And for the was it I who said something funny, or no?
Yeah, he stood to take a bow.
Oh, did two people stand and take a bow, or just one? Oh.
They will stand and take a bow right now.
Both of you stand and take a bow. I mean, I'm told they basically gave up their summer doing this, and it was just a very great and very timely, among other things, fact pattern, and we thank you for that. Now, as to the, this is my 23rd year as a judge, and for many years I was a regular on the circuit. I've probably heard 100 circuit arguments over the years on the Third Circuit, as well as, I can't count the number of arguments I've had at the district court. And all four of you performed wonderfully, and certainly consistent with the kind of performance I see from behind the bench in the, quote, real world. And you're all of you are to be congratulated for the high quality of your argument. I'm only going to make 2 points, because and I join in, obviously, in the points that the other three justices made. The 2 points I want to emphasize is, number one, it should be in your mind that a question from a judge is not something necessarily to fend off. It's an opportunity, because the judge is telling you in a way what's on his or her mind, and you should look at it as an opportunity to strengthen your point. Many times the questions will be softballs. And I've seen times when a softball question is thrown out, which actually is to help the arguer, and their just reactions, it's a question, it must be hostile. So look at questions as an opportunity. It's an opportunity to help the judge go your way. The second point, which has already been made, I think, by everybody, is that all four of you clearly had mastered the record. I mean, there was no, you all knew the facts, you all knew the record, and were very subtle in your appreciation of what the facts were. On the other hand, there's probably 15 cases out there that maybe even more that are in some way relevant to the dispute, and fundamentally, other than Heller and Hobby Lobby, we didn't hear much about some of these other cases. And I think, particularly at the Supreme Court level, but it would be true at any level of argument, you have to balance your appreciation of what the facts are with what the law is. And as I say here, in fact, many of the cases, if not most of them, were summarized at some point. And that's the one maybe overall comment I could make, that probably I would have liked a little more integration of the facts with the law. And but other than that, you all did yourselves proud. It's just hard for me to imagine that you're fundamentally first-year students, and you're now rising second year, but except for 3 weeks of the second year, you've completed your first year. You haven't had constitutional law yet. I guess you're taking that now. And you all did marvelously, and I think we should have a round of applause for all four of them. With that, I declare this session of court adjourned with our thanks.
Thank you.